Welcome to another episode of the Accidental Landlord Podcast. I'm your host, Peter McKenzie. And today we are going to be kind of recapping, closing out 2024, looking to 2025 from a legal perspective, which is really important for our listeners because, in our market in California, there's a ton of regulation, and we're going to kind of hit some of those highlights today. Our mission is to make managing your property and being a landlord or a new landlord as stress-free and uncomplicated as possible. So here's what we're going to talk about: the ever-changing regulatory landscape in 2025. We're going to talk about why keeping up with compliance, especially in California and Ventura County, matters. Everybody knows it's something you should do, but why? Sometimes that's important as well. And then what you need to know to avoid fines, build trust with your tenants, and stay profitable, because most landlords are doing this to produce a return. So, all right, let's jump right into it. So the first area we want to talk about is really the biggest one. It's the state of California. What has the state of California done from a regulatory perspective in 2024 going into 2025 that's going to affect you and how you manage your property and how you run your rental property business? So some of this is review, and then we're going to get into some new stuff too. So the biggest overarching law that changed the landscape was Senate Bill 567, which is just a continuation of Assembly Bill 1482. These are all related to the Tenant Protection Act. It's, in essence, statewide rent control and just cause eviction. If you are interested in the details about this, we have done a podcast about this specifically in the past. Go there, take a look. But essentially, you just can't raise the rent whatever you want to raise it, and you just can't tell your tenant to move. There are laws and complexities surrounding that you need to be aware of so that you don't get yourself in trouble. And then if you are going to raise rents, which we recommend raising rents in small increments annually, but if you are going to do it, you want to make sure that you're putting it through the lens of that law, that you're not breaking the law, because we're going to get into some penalties. There are real consequences for breaking these laws. The cost of noncompliance: fines. Tenants can file lawsuits against you. The cities, the city attorneys or the county attorneys also now have the ability with Senate Bill 567 to file a lawsuit against a housing provider. So just know that they're putting teeth behind these laws. That is potentially, something that could materially affect your business. Okay, let's talk about new laws. These are, I don't know if I'd call these exciting. Some of them are comical, but let's get into them. So we're just going to rapid fire through these. There's no way we have enough time to go into all the details. If you're interested in the details of these laws, you can reach out to us, do some internet research on your own. I'm just bringing some awareness to the top. I think we have 6 or 7 that are going to affect your business. Understand, they passed a whole bunch of laws related to housing, both purchasing and renting. I think on this one document alone that we get from our law firm, there's over 25 new laws. I'm just highlighting the ones that I think matter for our listeners. Number 1 is Assembly Bill 2493. It's about application screening fees. So in the past, you kind of had the discretion to approve applications however you liked. Obviously, with adhering to fair housing laws and not discriminating against people. But there's 2 things. One is you approve the first qualified application. That's one strategy. The other strategy is you collect all the applications and you approve the most qualified one. Well, this law is going to penalize people who are trying to approve the most qualified one. So they're basically saying if that's your strategy, you have to return managed application fees for people who didn't get approved. There's some more nuance to it, but essentially that's it. What the state is trying to do is get housing providers to approve the first qualified application. All right, well, moving on. The next one that's a big deal, especially for a mom and pop landlord, is Assembly Bill 2801, and that has to do with security deposits. Essentially, this is the state coming in and telling you exactly how you're going to deal with a security deposit disposition. And what that is when your tenant, let me back up. When your tenant moves in, they usually pay a security deposit. When your tenant moves out, that's the time for you to return the security deposit to them, minus any damages. And this has always been a gray area, which leads to frustration for both landlords and tenants. The state is now trying to put some structure around it. Example, they're trying to say you have to take before photos, you have to take advertising or after photos, you have to show those photos to the tenant. It reinforces some of the things that most people should know, which is the difference between damages and normal wear and tear, although it's not clear, it's still vague, which is part of the thing about these laws that always irritates me is they're trying to improve things, but because most of the time they're gray, it leaves it up to interpretation, which leads to frustrations for both parties. So take a look at that Assembly Bill 2801 about security deposits. Next one is Senate Bill 611. This has to do with fees and what you can charge your tenants. Some landlords, if they have to post a notice, are charging the tenants. If there's behavior from the tenants that is costing them money, they want to be able to charge fees for that. This law is going to severely limit that practice. Again, there's a lot more to it than what we're going to go over today. The other big change of this one is they are applying some of the laws that apply to residential tenants to commercial tenants. So if it's a small business, they're calling them a qualified commercial tenant. They're going to have some of the same protections that residential tenants have. In the past, commercial tenants were a whole different game, different set of laws. They're trying to change that. Assembly Bill 2747 is a mandatory offer of credit reporting. And this is going to be problematic for a mom and pop landlord. It doesn't apply to all properties. I think it only applies to properties that are 16 or more units. So basically small apartment complexes. But essentially what it is you have to report to the credit bureaus your tenant's payment history. And they're trying to help tenants by building credit and doing things like that. But that's a big lift for mom and pop landlords because some of them aren't sophisticated enough to figure that out, or there's some challenges around that. So take a look at that. If you have a property that applies to, that's going to change the way you operate your business. And then I think the last one that I want to go over is Assembly Bill 2622. This talks about contractors. So in the past, you cannot pay someone who doesn't have a contractor's license anything over $500. So you have a problem at your house, you call somebody over to fix it, a handyman without a contractor's license. If it's over $500, technically they're not supposed to do the work because that would require a licensed contractor. They raised that threshold to $1,000. This is a good law because the $500 limit had been there for years and years and years, and everybody knows stuff is way more expensive. So that gives a little more freedom to legally pay someone who doesn't have a contractor's license up to $1,000. So I hope that doesn't scare anybody, but those are some of the laws that I think apply to our, properties that our listeners may own. But like I said, there's much, much more. And it's important that we stay up on these because they change the way you operate your business. All right, let's talk a little bit about local stuff. So we manage in Ventura County, which is the county north of Los Angeles, south of Santa Barbara in California. There are a lot of we're in a coastal market. So there's a lot of short-term rentals because it's, we're at the beach. There's a lot of people that go on vacation at the beach. Some of the cities are becoming more strict with the enforcement of their laws, the city of Ventura being one of them. They had a bunch of regulations. Quite frankly, they weren't enforcing them. That's changing. They're making a push to enforce those things. So if you own a short-term rental in Ventura, take a look at the laws because they're starting to do something about it. City of Oxnard, all the cities essentially have regulations of short-term rentals. If that's your business, make sure you're paying attention to it because you don't want to be caught by the city. Creates a whole host of problems for you, and that's something you want to avoid. Now, let's talk about local rent control and local eviction protections. There are cities in our area who have their own rent control just cause eviction provisions. The two that come to mind are the city of Oxnard and the city of Ojai. Those are already in place, and nothing really new happened with those this year. The city of Ventura has their own. There was something called a rent eviction, which was essentially they're telling tenants they have to leave so they can fix the properties up and then rent them for more. So a couple of years ago, the city of Ventura put an ordinance on the books saying there's rules to that. You can't just do it willy-nilly. But what they're talking about now is creating their own city of Ventura rent control just cause eviction. There's talk of a rental registry, which I think is really bad for landlords. But just know that they're actively talking about that. I've attended some of the meetings to try to, represent mom and pop landlords, but that's coming down the line and, hopefully it doesn't come to fruition, but there's a chance that it can. The importance of this is if you're in these areas, you have to know what's going on because they're smart. They're going to figure these laws out. And if you, as the landlord or the mom and pop landlord, have no idea about the laws, you're putting yourself at risk. And housing is a very political, touchy issue in our area. You don't want to be on the back foot when it comes to this stuff. I believe most people are good, and very few people intentionally break laws, but a lot of people unintentionally break these laws just because they don't know about them. And frankly, it's really difficult to stay on top of this. One of the reasons we do this podcast is to try to educate people on what's happening out there. Okay, let's move on to a conversation about compliance. How can you stay compliant with all these laws? Because this is what we do full time, and it's difficult. I'll be open and honest and transparent. It's hard to stay on top of these laws because, one, there's a lot of them. Two, the laws conflict with each other. You might be following one law intentionally and intentionally breaking another law. The problem is the laws don't agree with each other. The laws are just, I don't know, they write these laws in a vacuum or what, but it's difficult to do. So that leaves you in a position where you have to make judgment calls on risk, like which one's riskier. You're not going to be able to fill both of them because it's physically impossible. This is where you need competent legal advice. I would make sure you have an attorney on your team who understands this. Obviously, we're not going to go for a personal injury attorney to deal with specific landlord-tenant matters in a specific area. So just make sure if you have to make these calls, which you may find yourself in those positions, that you have competent legal advice. The other thing you want to do is you want to do regular compliance audits. If you drew up your lease 10 years ago and you're using the same one today, I'm here to tell you your lease is not compliant with a bunch of laws. So you need to put a system, a process in place in your business that regularly looks at these things, sometimes belonging to professional associations, the California Apartment Association. We belong to the National Association of Residential Property Managers. There are groups that help you with this. But if you just got your lease off the internet, guaranteed you're out of compliance if you got it even 2 years ago because the laws change so quickly. So if this is something that we help landlords with, this is one of our areas of expertise. We review, if we bring a new client on, sometimes if they have a tenant already in place, first thing we're going to do is read that lease. And if the lease is not compliant with the current law, we have to change that immediately. The other thing you need to do, or that can help in the compliance arena, is staying informed on the changes. Figure out where you're going to get your information from. There are, like I said, associations of landlords that provide this. There are law firms that provide this. Our particular law firm we use is Kimball, Tyree, and St. John. They have excellent information on their website. There's webinars. There's all kinds of information out there. You just want to make sure that you have somewhere to get it and that the information is accurate. There's a lot of misinformation. There's a lot of YouTube channels that talk about a lot of this stuff that makes me cringe sometimes because some of it's accurate, some of it's not. And if you're taking your advice from somewhere where you're not getting accurate information, it's going to put you at risk. So you need to stay ahead of the curve when it comes to this stuff. The other thing with compliance, which is I think what most people do, is they leverage professional expertise, whether that is a landlord-tenant attorney with a specialization in that area, or they work with a professional property management company who's known for staying on top of these things. That's a way for you to provide leverage. Because frankly, one, this is a very boring topic. Nobody gets up in the morning and goes, I'm going to learn as much as I can about landlord-tenant law. And two, everybody's busy. Everybody's busy doing the things that they do to make their household run, their careers, their families. This is not high on anyone's priority list, although it should be if you're a landlord. But if you leverage other professionals who this is their job to stay on top of, it's a great way for you to stay on top of this stuff. So property managers, real estate attorneys, some financial advisors, these types of things. It can reduce the risk to you and save you time. Okay, so let's have some closing thoughts. Let's talk about why compliance is important. And in my mind, compliance isn't just about following the law, which in itself is difficult to do. But compliance is about protecting your reputation as a landlord. You go make some mistakes against some of these laws, and some tenant advocacy group gets a hold of you, they could make you the poster child of bad landlords or a slumlord or something along those lines. That's a real risk. You don't want that to happen to you. Even if you don't get penalized by the government agencies that have the ability to fine and penalize you, it's still a risk, which is why it's good to stay on top of compliance. 2, it builds trust with your tenants. Your tenants will figure these laws out, especially some of the more popular ones. And we don't want to have an adversarial relationship with our tenants. In our particular company, we believe that taking really good care of the tenants is really important, because guess what? If you take good care of the tenants, they're going to take good care of the property. They're going to be reasonable. Everything is going to work as it should. But if you're a landlord who ignores laws and ignores compliance, quick story I'll say here. I was meeting with a landlord once, and his strategy for dealing with compliance was, I don't follow any of the laws. I just wait to see what happens. And then if I have to, I'll offer the tenant some money. And the cities have tried to sue me and do all these things, and I just do the absolute bare minimum to stay, out of big trouble. That is a terrible strategy for compliance. And this gentleman basically told me this to my face, and I was like, I don't think we're the right company for you. There's no way that I'm going to endorse that kind of a strategy when it comes to compliance. It's bad all the way around. But building trust with your tenants, keeping the relationships good is important. And one of the ways you can do this is by being compliant with the laws. So it's going to take some proactive planning. Have experts on your team. Nobody can do this on their own. Frankly, we don't do it on our own. We have legal experts that we talk to, both from the attorney side, the CPAs, financial planners. You need a team to do this business successfully, because it's not one professional that knows everything. And if anybody ever tells you that, you should run. Okay, that is the extent of the episode. If you like this content, if you want to talk about your personal situation, feel free to reach out to our company, Rincon Property Management. We're happy to have these conversations and or point you in the right direction if you have a specialty item that is not something that we can help you with. If you go to our website as well, we have a lot of educational resources. It's rinconmanagement.com. There's a learning hub there that has a lot of information that can help you kind of level up your business and run it in a professional manner. I want to thank you guys for tuning in. Hopefully this was helpful. If you want to keep on top of the information that we're providing, please subscribe to the podcast, leave a review so we can help you manage your property in a stress-free manner. Thanks, guys.